Well, I'm here with my friend and Enid attorney Randy Long, and we're going to talk about power of attorney and medical directives, something that every single person should have in effect and almost nobody does.
You're exactly right, Bob.
So let's start with a little bit of talking about the power of attorney, what it is, how it works. Just start there, Randy.
Sure. A medical power of attorney gives a person the ability to designate and make decisions or handle their affairs for them when they're unable or just as a matter of convenience. There were two main types of powers of attorney that we always talk to people about. Normally when they come in for a will or a trust, we're going to mention to them that it's important where the will and trust takes care of what happens with their estate after they're gone. They need to consider that they may need some assistance during their lifetime. And if you don't use a power of attorney, your family's only other alternative is to go to court, file a petition for guardianship. That's a legal proceeding that's going to be a lot more involved, cost a lot more. Power of attorneys are relatively cheap, especially compared to litigation. And you can designate a person, like I said, to act on your behalf. The two main types of powers of attorney that we've used in the past, and I'll explain here in a minute why I say it that way, is a medical durable power of attorney and a general durable power of attorney. Durable in the name just simply means that it survives your incapacity, because historically a power of attorney, and again that has been around for centuries, where a person can give another person a power to do a specific act, sell my house, sell my horse,
sell my car.
Exactly. Or for a wider range of purposes. What we're talking about in the general durable power of attorney is to handle your personal business affairs, your banking, collect your debt, sell your property, whatever you would do in your personal business matter. And a lot of times we make those effective immediately, because we found over the years that those are used many times more often for convenience than out of necessity. But with that durable language in there, then it survives your incapacity. And before that became available, if you became incapacitated, your power of attorney was no good anymore. That was the historical.
Oh, wow.
The power of attorney was only as good as the person who gave it.
Wow.
And that goes back to the medieval times in England and so forth. So when they added that durable language, best of my memory, sometime in the 80s, the use of powers of attorney mushroomed. Because again, it's a cheap alternative to doing that guardianship. And the beauty of a power of attorney, if I give you a power of attorney on my behalf, I don't lose the power to act. So I still have the power to act. I've just created, the best analogy I can make is an alter ego. But if you undertake to be my power of attorney, to be my agent, or the law calls it attorney in fact. I'm an attorney at law because I've got a law degree and a license. But if you were my agent under a power of attorney, you would be what the law calls attorney in fact.
Okay.
But you are a fiduciary, and that means you agree to stand in my shoes, to act in my best interest, to do as best you can determine what I would do, preserve my estate, not squander it, not take a trip around the world on my monies. So there are some legal protections in making that designation. The other form is the medical power of attorney to make medical decisions, and a lot of times we don't make that effective. It has what's called a springing power, and that just means when you sign it, no one has the power. It only happens if some future event you've designated occurs. And so for medical, most people want to make their medical decisions for so long as they are able, and only when they are no longer able do they want to designate a person. And normal trigger that I find in the ones that I prepare is when their then attending physician, the person taking care of them whenever the heart attack or whatever the health care issue is going on, because that doctor is in the best position of anyone to say, yeah, they're not capable of making this decision, then the person they've designated can make that decision for them.
Okay, and you know, I can speak from personal experience the importance of a power of attorney. This last year, well, been 2 years ago now, my mother-in-law went into the hospital and was in pretty serious condition, and we couldn't pay her light bill, we couldn't pay her phone bill, we couldn't do anything because we did not have that power of attorney in place. So people need to get that power of attorney, don't they?
They do. And when I said we used to have earlier, effective November 1st, 2021, a new set of laws, it's called the Uniform Power of Attorney Act, which was just a revamping. We're used to the legislature constantly passing new laws, tweaking, if you will, adding to, taking away. Every once in a while, they see fit to rewrite a whole area of the law completely. And that's what happened the last legislative session and went into effect November 1st, they rewrote the whole law concerning powers of attorney. And they left out, and we don't know yet whether that was intentional or unintentional, but they left out medical powers of attorney. Thank goodness the new legislation does provide that if you have a power of attorney prior to November 1st, 2021, those are still effective and those are going to be honored. So your medical power of attorney made prior to November 1st, 2021, if you have one, it's still good.
Right.
But for those clients that have come in since November 1st, I've had to tell them I can't do you a medical power of attorney. Again, we think it was done in error or was an oversight, which happens just because of the legislative process. And so we really expect that the next legislative session, if it was in fact an oversight or an error, that they will fix it and put those back in.
Okay, so in kind of wrapping up here, what's the process? I mean, can I just whip out a napkin and write down power of attorney, or what's your best recommendation?
Well, you can do that, but we're not going to find out till it's probably too late. We're not going to find out till you're trying to use it, whether it's any good or not. So again, I've got to encourage you to go to an attorney, and again, I know that's self-serving, but I don't care who the attorney you go to, they know what they're doing. There is a form, there's a statutory form, but it's got a lot of blanks in it. And it's an important document that is very useful and very beneficial, but it can have some unintended consequences that if you mistakenly thought one thing and it does another, or you thought it did something you wanted to do and it doesn't. So you can get that form, but again, most attorneys, it's a nominal sum to do that, and I would have to say it's well worth the money to do that.
You know, I think one of the reasons I deal with seniors a lot, so they feel like if they give somebody a power of attorney, they've lost control.
Sure.
And they really haven't. They're still in control. They're still able to keep an eye on things. It doesn't take away their independence, and a lot of times it really aids in their independence. Like my mother-in-law could have lost her phone, her lights could have been turned off, her gas could have been turned off. She could have been behind on her rent because we didn't have the ability to pay. Luckily, we were able to get a power of attorney and get it notarized there at the hospital. But if you're a senior and you don't have a power of attorney, or anyone really, you know, myself included, we should have something in effect so that if we're incapacitated, somebody else can make some decisions and at the very minimum pay some bills.
And that's one of the changes in the new law. Used to, we had to put that durable language in there. Now the law is kind of caught up with the times, because I can't tell you last time I did one that didn't have the durable language. So the new law says all powers of attorney are durable unless stated otherwise. Okay. And so again, the person you name is a fiduciary and they have an obligation.
So Randy, does the power of attorney last after death?
No, no power of attorney survives death. It's only for the living. So the minute a person dies, the power of attorney, the agent or attorney in fact, cannot act at all. I mean.
So then we get back to you better have a will to follow up with the power of attorney.
That's correct.
Okay. Well, I hope that we've brought some thought-provoking conversation here today that will make people think that, hey, I need to put some of these things into effect, and just to make sure that my light bill's paid and things are paid if something does happen, because we never know, do we?
Nope, we sure do not. And
don't be like me. My mother-in-law's already in the hospital and we're scrambling and trying to get everything together so we can pay her bills. So don't do as I do, do as Randy says. And Randy, thank you. If they have any questions, the phone number's up there on the screen and they can feel free to call you.
Absolutely. My privilege. Thank you, Bob.
Thank you, Randy.